This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. I'd like to welcome you to the FCPA Compliance Report on the Compliance Podcast Network. I have back with me fan favorite James Koukios. We're here to talk about the firm's April 2019 Top 10 International Develops in Anti-Corruption newsletter. We take a look at the debate over meaning of agent as the Hoskins trial nears, how the federal court found an FCPA investigation protected by attorney-client privilege, the International Maritime Organization sets up an anti-corruption agenda, and we take a deep dive into the Evaluation of Corporate Compliance Program's 2019 guidance, asking what, if anything, is new, how does it assist the white-collar defense attorney and the compliance professional, and should it be read in conjunction with the Benczkowski Memo, which was issued back in April of 2019. I know you'll find it interesting. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Hello, everyone. This is Tom Fox, back for another episode, and I am joined once again by James Koukios. That's fan favorite James Koukios, here to talk about the Morrison and Foerster April 2019 Top 10 International Anti-Corruption Development newsletters that the firm puts out. We're going to link to the newsletter in the show notes, and I encourage everyone to check it out because it's got a lot more information than we're able to go over in our podcast. But James, first of all, thank you for taking the time to visit with me, and welcome back.
Tom, thanks for the invitation. It's always a pleasure.
So, James, we have even up until the day of this recording, a highly contested case that may be going to trial, hopefully at some point. But it involves the Hoskins Matter, and this is continued fallout from the Alstom FCPA enforcement matter from a couple of years ago. Lawrence Hoskins was one of four individuals who worked for Alstom who were individually charged. And we've had, in this newsletter, you guys talked about the debate over the meaning of agent. So I was wondering if you might be able to detail the positions and where it might be heading on this issue, because there's a lot more.
Yes, this is a very interesting case. We've been following it for a long time, and I think most people in the space have been. It really focuses on some of the criticism that a lot of people have had about the FCPA and DOJ in particular's approach to FCPA jurisdiction. A lot of people say that DOJ takes a position that the FCPA jurisdiction is limitless, and so DOJ can police the world. And Hoskins really goes right to the heart of that criticism. Long story short, Hoskins was a non-U.S. citizen. He was a citizen in the U.K. He was working for a non-U.S. company, Alstom, outside of the United States, the U.K. and France, and allegedly participated in a bribery scheme involving the Alstom's Connecticut subsidiary looking to do business in Indonesia. And DOJ said, although Hoskins never set foot in the United States, he conspired with the U.S. entity and people from the United States to pay bribes to Indonesian officials to win a power plant contract. Now, Hoskins raised the argument that I'm outside of the FCPA's jurisdiction because I never set foot in the United States, and you can't use conspiracy. I don't work for a U.S. company, et cetera, and you can't use conspiracy and aiding and abetting to get me within the jurisdiction of the FCPA. For a long time, DOJ said that's exactly what we can do, and we're going to do that. In this case, the district court in Connecticut and then ultimately the Second Circuit Court of Appeals agreed with Hoskins and said that, yes, as a non-U.S. citizen who did not work for a U.S. domestic concern or a U.S. issuer, he's not within himself the FCPA jurisdictional scope, and you can't use under Second Circuit precedent conspiracy and aiding and abetting to expand that jurisdictional reach. But the court said, if you can prove that he was an agent of the Connecticut subsidiary, then that falls within the statutory language and the jurisdiction, and you can convict him. Now, unfortunately, the Second Circuit did not define what agent means for purposes of the FCPA. And so the litigants, Hoskins and DOJ, now have to argue for jury instructions. What instructions should the court give to the jury to determine whether Hoskins was acting as an agent for the Connecticut subsidiary? Not surprisingly, the two parties disagree. Hoskins is taking a much narrower view, and DOJ is taking a much broader view of what it means to be an agent. And it's really interesting here. Everybody agrees, Hoskins and DOJ agree, that the court should use the common law definition for agent. So in other words, FCPA doesn't define it. And so both parties agree we should go to the common law and use the definition of agent. They both agree that an agent is controlled by a person or company that it performs a service for, but then they disagree on the next step, how that should apply to Hoskins. DOJ says it should be a fairly broad meaning of control, including that control may be inferred circumstantially and from the words and actions of the parties involved, whereas Hoskins takes a much narrower and more formulaic approach to it. So it'll be really interesting to see what the court decides to do in terms of the instruction, and then it'll be interesting to see what the jury, if it does go to trial, what the jury will find there. For practical purposes, if DOJ gets a favorable ruling on the instruction and is able to convict Hoskins under that, then the jurisdictional limitation by the Second Circuit may not be as severe as it may seem on first blush, and DOJ won't be able to use necessarily conspiracy and aiding and abetting anymore, but may be able to use an agency theory going forward.
Let me geek out with you for a few minutes, James.
Yeah, sure.
I guess my confusion, or at least my question, relates to your language around a jury instruction. That implies to me that it's a factual-based analysis. I would have thought that the court would have ruled on agent status as a matter of law. Yeah,
agent status is a factual matter. The definition of what agent is a question of law, but whether somebody meets that definition is a matter of fact for the jury to decide.
Oh, okay.
Yeah,
well,
it'll be interesting. It'll be very, very, very. We had this sort of similar issue in Eskenazi and about what is an instrumentality of a foreign state, and our first position was that was a question of law, that the judge should decide as a matter of law whether Haiti Teleco was an instrumentality, and the judge said, "I'm not doing that. That's a question of fact." So we had to deal with a jury instruction for that, and we had to figure out how we were going to prove that at trial. And ultimately, we were successful, and the 11th Circuit agreed with us and agreed it was a question of fact and put out the Eskenazi factors. But yeah, it's interesting, and it just goes to show this one statute, which doesn't necessarily seem that difficult when you just read it at first blush, has a tremendous amount of nuance that is sort of being fleshed out in real time in some of these cases, like Eskenazi before and Hoskins now.
So the next issue, James, is I found this really interesting. The International Maritime Organization set up an anti-corruption agenda. And what I found so interesting about this was this is a business trade group, or excuse me, it's a part of the United Nations, but it specializes in shipping and really maritime issues. And they recognize the unique nature of the potential of bribery and corruption in their industry. And I was wondering, from the newsletter's perspective, or where you guys sit, do you see this as something that other NGOs and maybe even trade organizations are beginning to take a look at bribery and corruption internal to their specific industry or their specific business and try to help companies navigate that?
I do. I mean, there's a lot of trade organizations out there that do regular training and have conferences and guidance for their industry members on avoiding corruption. The maritime is interesting. I mean, this is always one where it just jumps out as a high-risk industry because you're going from port to port around the world. And when you're going to these ports, you're just inherently and inevitably going to be dealing with foreign officials, whether it be customs brokers or maybe the port authority itself is owned by the local government. And so you can just see any number of opportunities for corruption. Not that they all are corrupt, obviously, but it's a high risk of that because of the heavy involvement with all the interaction with the foreign officials. So it's really good. I think, to my recollection, maybe a long time ago, but I don't think there's really been a maritime company or a shipping company, other than freight forwarders and things like that have had a public FCPA problem yet. But you just look at the industry and you think, they have to interact with foreign officials so much. There's got to be high risk, and so I think it's a really good. And the International Maritime Organization has realized that, and they see it as not only a corruption risk but a safety and security risk as well. Because obviously, you could be paying bribes to get terrorists to the country, nuclear material. Those are the worst case scenarios, but it can be really terrible. And so I think it's really great that the IMO has stepped up and said, we're going to publish guidance on how we should combat corruption in the maritime industry. And it looks like the solution is going to be that the IMO is going to propose that the IMO regulations and requirements for the maritime industry align with the United Nations Convention Against Corruption. It makes perfect sense. IMO is part of the UN. UNCAC covers all kinds of corruption, so it makes sense. But I think it's a really positive development, and it is something that we see other trade groups doing as well.
James, we had an interesting ruling, I thought, in attorney-client privilege issue for an FCPA investigation. And one of the things that I really couldn't tell from the write-up in the newsletter was whether the investigation only reported facts, whether the investigation reported facts and attorney-client thought processes, analysis, proposed remediation, and then also that this was in a civil case, not an FCPA enforcement action, where the claim was, I believe, of wrongful termination of a distributor. Well, what were your thoughts on this case?
So this is always a big issue whenever you're doing an internal investigation, whether it's in the FCPA or any other white collar or regulatory arena, is making sure that you're able to protect the internal investigation under the work product and attorney-client privilege doctrines. And defense counsel for individual defendants, and in this case, a jilted lover in some ways, are always trying to undermine that and get the underlying documents and things like that. So basically, just to set the stage here a little bit, what happened was in early April, the Eastern District of New York held that documents created by external counsel during an internal investigation into potential FCPA violations are protected by the attorney-client privilege. The court ruled that a U.S. medical device maker did not have to produce to a Chinese manufacturer documents created by its external counsel during an internal investigation into these potential FCPA violations by the Chinese manufacturer. The court rejected the Chinese manufacturer's argument that the documents were not privileged because external counsel had been hired to make findings of fact, not to provide legal advice, holding that fact-finding is a crucial part of determining proper legal advice, and that the two roles are not mutually exclusive. So it's always this fact versus law versus legal advice is always so critical, because on the one hand, when you're dealing with DOJ and SEC and other enforcement agencies, they ask you to provide facts, not privileged materials. And that helps companies say, we're not waiving the privilege because we're just providing facts. And it helps DOJ and SEC avoid, well, in DOJ's case, a policy violation. They're not entitled to ask for attorney-client and work product material. And so the Chinese manufacturer here tried to turn that on its head and say, well, look, you're internal investigators, you're working in an investigative function, you're just getting facts, so none of what you did was privileged. And the court said this is much more nuanced. Those facts were developed in large part in order for the lawyers to be able to give advice to the company about things like, how do you remediate within the confines of the law? Was there a legal violation? What legal obligations do you have going forward? And so the court held like these things are, when you're in the midst of internal investigation, they are not mutually exclusive. Fact-finding and providing legal advice, they're actually intertwined. And you're right, the ruling was made in a civil suit. That the distributor argued that they were wrongfully terminated, and so they wanted to get to the bottom of the facts and what happened during the internal investigation. And the court said the company did not have to produce all that material. So just a very good opinion to read for practitioners in this space, or companies that are conducting internal investigations and deciding how to engage counsel and which part of their internal investigative function to use to conduct investigations. Always have to keep those things in mind: attorney-client privilege and work product.
James, and now I want to turn to what may have been the biggest development in the month of April, and that was the announcement of the Evaluation of Corporate Compliance Programs 2019 guidance. I happened to be at the ECI conference where Brian Benczkowski announced the new program, so I was fortunate enough to hear some of his remarks about it. Of course, was able to download it and study it. And I really wanted to maybe get two or three of the key takeaways from you. First of all, is anything really new, or is it just perhaps a refocus a little bit?
I'd say it's more of a refocus. There's a lot of overlap between the two. There's nuances here and there that are different, but I think it's more of a refocus. I think the biggest practical difference here is that when the original corporate compliance guidance was released, it only came out on the fraud section's website. There wasn't a whole lot of fanfare. It wasn't even on DOJ letterhead. There's kind of a funny letterheads and blue triangles, things like that. And there wasn't any publicity about this. It just was released in the dead of night. Turns out it was an extremely helpful document. To try to understand, it was a series of questions that the fraud section may ask a company that's coming in to talk about the problems that they may have had and how they fixed those and how they're going to prevent them going forward. So it's an extremely useful document for companies to either prepare for a meeting with DOJ or to just benchmark their compliance programs. But technically, it only applied to the fraud section. Now what's happened is the Assistant Attorney General for the Criminal Division has taken it for the entire Criminal Division and said this applies to all of us in the Criminal Division. And we're going to tie it a little more tightly to the Phillips factors. And so we're going to kind of explain to you how these questions and these themes relate to the Justice Manual's federal principles of prosecution of business organizations, how it's all a cohesive whole, and we're going to have this apply to the entire division, not just the fraud section. So to me, that's the biggest. There may be individual changes that are significant, but overall, it's the expanded scope and sort of the expanded vision that I think are the biggest takeaways from it. I'm curious your thoughts, Tom, since you were there and you heard firsthand.
So, it reorganized things a little bit. I thought the opening three questions of, is your program well designed? Is it being applied adequately? And then does it work? Or a good framework to consider the specific elements that they then laid out. I thought for me the largest refocus was two areas. One was in culture. Certainly that has been a part of FCPA compliance programs at least since the 2012 resource guide. But here it was really focused in a way that I hadn't seen before. And the second thing was the 2017 evaluation really introduced the term operationalization. And this, the 2019 guidance had, I thought, a focus on continuous monitoring, but the next step, which is ongoing improvement of your compliance program based upon continuous monitoring. So people had understood continuous monitoring was needed previously, but I thought the emphasis or the tying of ongoing improvement directly from your continuous monitoring, i.e., a feedback loop or whatever you call it, in a documented way that you could demonstrate you were upgrading, you were watching what you were doing, you were learning lessons, and you were applying those lessons. If I could use some Texanese there, so I thought that was a little bit of different refocus, and I've really been trying to talk and emphasize that change. And really, the last thing was that it struck me that it really seemed to me that this was not so much part two of the Benczkowski Memo, but you should read them both as one lengthy dissertation from the Department of Justice, where the evaluation was sort of part one, and the Benczkowski Memo was part two, what you do if you find yourself in an investigation. And then, of course, the part about what the department had to do to justify a monitor. But I also thought there was a roadmap in the Benczkowski Memo for a company to avoid a monitor. So I thought really by laying them side by side and reading them all the way through, it provided just a wealth of information.
Yeah, those are very interesting points. I think both of those documents, Benczkowski Memo and the guidance, as we're calling it, are really important for companies to take a look at and to use as benchmarks for their compliance programs, and really see, if we do have a problem, how is DOJ going to evaluate this, and are we going to be in a good shape or not? And I think you're right. And if you can answer those questions positively, you're more likely to get a more favorable resolution, including no monitor. So they're very important documents for companies to pay attention to.
So, James, once again, this has been a fascinating exploration of the Morrison and Foerster top 10 international anti-corruption developments for April. I wanted to thank you again for taking the time to visit with me.
Thanks, Tom. Really appreciate you having me.
Hello, everyone. This is Tom Fox again. I hope you've enjoyed this episode of the FCPA Compliance Report. We'll link to the Morrison and Foerster April 2019 Top 10 Developments in Anti-Corruption newsletter in the show notes. Thanks again for listening to this episode, and I hope you'll join me again next week for another episode. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks again for listening.